those who are held pretrial suffer worse disposition, harsher sentences, and are more likely to recidivate.
I think maybe the most important hearing in many criminal cases is just simply whether the person gets out on bail or not.
A lawyer is not a luxury. A lawyer is a necessity. And every person needs to have a competent person at his side representing him and presenting his position at every stage of the proceeding.
There are two kinds of judges. Judges who get it and judges who don't. Judges who get it, give them something to hang their hat on. Give them the basis for getting it in that particular situation. Show them why, yet again, this person ought to be released. Don't take them for granted. Be as prepared for them as you are going to be for the ones who don't. Second, the ones who don't get it, it's war.
He wouldn't accept no from the judge, so he just kept fighting on my behalf.
It was incredible. I mean, I just felt like crying. I could not believe somebody was going to help him and help us.
You got to fight it. You got to fight it every appearance, every battle, every encounter. It's war. You're at war with that judge who doesn't get it. You don't accept it. You don't put up with it. You make the judge do the right thing by forceful advocacy.
If you know that you're the person who's standing between that person and prison and can make the difference and redirect that person's path, that can be all the motivation you need.
As the nation celebrates Gideon's 50th anniversary of people's constitutional right to a lawyer, it is time for the Legal Academy to examine one of the glaring weaknesses in states' pretrial justice systems. Throughout the country, poor people are not represented by a lawyer when they first appear before a judicial officer and do not always receive a lawyer's robust and vigorous representation when freedom's at stake. Just how important is a lawyer's early representation?
It's indispensable.
My experience teaches me that it's absolutely necessary to have a lawyer right at the very first outset, the very first hearing.
I think on a scale of 1 to 10, with 10 being the best,
the answer is 20.
I would rank it at a 12. It's more than 10.
It ranks at the very top. It ranks as the most important thing. Take a person whose case is ultimately going to be dismissed. If they're held pretrial, they lose their job, they may very well lose their home. Ultimately, they may be released, the charges may be dismissed, but their life has been ruined.
Well, a lawyer is absolutely necessary at the first bail hearing. And the reason why that is because it gives the client from the beginning a degree of credibility.
And you're the only thing between that person and the 7 by 10 prison cell.
I mean, that's how important your role is. They're looking to you. They're afraid. They don't know what's going on. They don't understand what they're supposed to say.
For so many reasons, that first appearance is so important. Primarily, once a number gets set, it's so hard to move off the number.
We know that money, it means incarceration for most of our clients, and oftentimes a ridiculously small amount of money is all it takes to keep people in jail.
The difference between trying a case with a client who is out on bail, with his or her family around them, with his own personal sense of I'm a human being, not a uniform in a little cell, that difference, you can't quantify it.
In our pretrial justice system, money often decides freedom or incarceration before trial. What does a lawyer say to the judge who's ordered a bail that you know your client cannot afford?
when you've got a client with basically no resources and the judge is saying, you know, it's a $10,000 bond, you can post $1,000. The argument I usually make is that, Your Honor, in this case, 10% bond is like saying $1 million. And make them, you know, look at the income, his income or his family's income, or who he's supporting.
Well, I've seen courts where people are arrested on minor charges and spend 3 months in jail and then are given the opportunity to plead guilty for time served. Of course, what's interesting is those same judges won't release the person on their personal promise to come back. They'll release them if they plead guilty, but they won't release them if they demand a trial.
My experience over several decades as a judge is that very few people flee the jurisdiction where charges are placed. And that's the only purpose of a financial condition.
Judges who set bail, prosecutors who seek bail, defenders who accept bail, all do so with the belief that it's what's required to get the defendant back and to keep him or her out of trouble. We know that to be nonsense.
And we should presume that there's no presumption that a person is going to not appear. So we should be presuming that person is going to take a court order seriously unless he has demonstrated the opposite in the past. And if a person does have a prior record and you're looking at that prior record, if that person has appeared for court consistently, then that's a good sign that this person knows how to take a court order seriously.
Sure, some judges are harder to persuade than others. Some judges may be impossible to persuade, but we can't run the system based on the worst case scenario. Many judges welcome this kind of information.
And the public defender, in all of her words and actions in front of that judicial officer, must make plain to that judicial officer that this individual is deserving.
Lawyers make many different arguments when their client's freedom's at stake. What type of advocacy is most effective?
I tell those lawyers to remember why they're there and to remember their client. For their client, this is not routine. It may be routine for the judges, it may be routine for the prosecutors, it may even be routine for the public defender who's been in place for year after year, but it is not routine for that client. They should remember what kind of representation they would want at a bail hearing if they themselves were the accused, what kind of representation they should be providing if it were their best friend.
If I'm in court and I'm watching bail hearings and I see a representation which seems very routine or rote or non-existent, it makes me very uncomfortable because I know the difference it makes, the impact it has at that stage for the individual.
The process is too serious. You're the guardian of someone's liberty. If you undertake that responsibility, undertake it 100%, not 90%, not 50%. And I would see all these 20%ers in my courtroom. And I was tough on them. And it was embarrassing for them. If they didn't do the things that were necessary to represent a client's best interest, to give me the best view of that client and his situation, I was angry.
You fight and you fight extremely hard so that your client can see, because now we're at pretrial. So you're at a point where you're trying to build client relations. So at this point, you need to fight as hard as you possibly can. So if you lose and your client is detained, when you go visit your client in jail, he's gonna know this guy's gonna fight for me throughout the course of my case.
You have to do a good job. You have to advocate on behalf of the client. You have to have the client hear you advocate for them. You have to have a judge hear you advocate. The judge knows you're the only person there for your client. If you're wishy-washy about the reason why your client should be out, you've lost the fight.
He went to the distance to see what kind of background I had and see what really could convince him to really fight for my case. And that's what he did.
They have to be believable, and that's what his student lawyer was like. She gave a great history and, you know, the program that he was accepted into and why this was good for him.
It made a big difference about me getting out of jail, because it made me realize that the things that I was doing was wrong. And it really made me realize that I had a second chance to change my life.
What must every lawyer do when first representing a client?
I think that there's also a lot of personal satisfaction in knowing that you were able to change those outcomes for a person just by doing a little bit of due diligence, and just by knowing the law and spending 3 minutes in front of a judge or 2 minutes in front of a judge making a strong argument.
The judges can't make these decisions on their own. They need the information. And who can provide this information? The lawyers. The lawyers provide the information to judges. They bring people to court and they present verified information, and this allows the judge to make a more favorable decision.
It's important that you present the court with verified information. The judges often look for whether or not a client has a home to return to.
I call them ties to the community. And so we're talking about a job, we're talking whether that person has a job in this community and an incentive to stay in the community because that person has a job here. If that person has family in the community, that is another incentive to remain here, to not run away.
When the defense lawyers, whether public defender or private, gather that information, verify that information so that the facts can be checked and present that, it's huge.
Lawyers should absolutely try and talk to pretrial before the bail review begins. I mean, that's a great time. Usually everyone's waiting for the judge to come on the bench, so if you can get there just a few minutes early and get their ear and explain to them as much information as you can about your client, see what they've been able to find out about your client, and if they haven't been able to find out information or interview them or verify anything about your client, you can then provide them with that information and share it with them. And try and reach an agreement with pretrial as to what the bail recommendation will be.
There's some courtrooms where if you have 30 seconds to argue before the judge, you'll be lucky. 10 seconds, some judges. And if you have 5 minutes before the case gets called, you're lucky. I know that world.
Use the time that you have. Whatever time it is, be it only a half hour, that's time enough to make a phone call.
If you are known as someone who's there to fight for your client, and you're respectful, and you're prepared, and you know what the law is, you, I think, in the end, will get a lot greater benefit for your client and for yourself.
The studies make clear that a client who is at liberty, even one under some conditions, but a client who is at liberty pending trial will be a better client, a more trusting client, will work more closely with the attorney. The attorney-client relationship will be enriched, and the likelihood of a positive outcome will be increased.
I would want to encourage the attorneys and the management staff for those attorneys to keep pushing back against the system. The system has a weight all its own, and in some ways it's designed to crush your client's opportunities and crush your spirit. And you have to remember that you're the one who's there to stand against that, to push against that.
One thing we all have to say every day is that we can't say we've always done it this way, or we can't do it in a different way here.
Justice should not be denied because of poverty. You should, to Justice Black, that was just unacceptable, and should be unacceptable in a decent society.